The biggest challenges for a lot of founders is raising money, and there are different options available. A few years ago, you had to always go the private route, and you had to work with a VC fund or an angel fund. These days, there are a lot of online platforms that allow you to raise this money, these platforms provide some services, but at the end of the day, you as the company has the ultimate responsibility when it comes to complying with, for example, tax and securities law concerns. So in this video, I'm just going to quickly talk about what it means, what are the key rules under Rule 506C, which allows you to do general solicitation. Keep in mind, this is still a private placement. We're not talking about public securities here. So some of the key things to consider in a Rule 506C offering is that there is no cap on the amount that you can raise, so you can raise an unlimited amount. However, all investors must be accredited. There's unlimited number of investors, but they all must be accredited. And how do you make sure they're accredited? You go through a verification process. You could, essentially you should need to take reasonable steps. Sometimes people will, send out questionnaires and have investors self-certify. That alone is not enough. You need to actually take further steps. Maybe look at their financials, look at the statements they provided. It is your responsibility to make sure that you've taken reasonable steps to make sure that they're accredited. Certification alone is not enough. Sometimes some platforms do provide a verification service, so you need to shop around and see which one works best for you, and then read the reviews, talk to other founders who've used that platform and see how it worked for them. Like I said, under 506C you can do general solicitation, and that essentially is your advertising on the internet. If you compare that to Rule 506B offering, which doesn't require, it doesn't allow general solicitation, but it does have other benefits. For example, you could have up to 35 quote-unquote sophisticated investors that are not accredited. There's no definition of what is sophisticated, so that again is your responsibility as the issuer to make sure they in fact are sophisticated enough in their knowledge of business and finance to understand the risk associated. Another requirement, if you're doing 506B offering, is that you will need to, for the unaccredited investors, you will need to share with them all the key risk factors. That essentially means you will have to prepare some sort of a placement memorandum or disclosure document that will have all the key risk factors associated with it, including, for example, risk factors related to the offering, whether it's debt issuance or equity issuance, risk factors related to an industry, the team, any other risk factors, categories of risk factors that investors need to know. Under 506C, there is actually no requirement to have an intermediary or placement agent. However, most people do use one. So if you use an intermediary, they do it all the time. So it will obviously help you. Finally, as far as SEC filings, there are notice-only filings, so you need to do a Form D filing within 15 days of first sale, and you also need to make sure that you're doing filings in the various states where the investors are based, and that's usually the same rule that you file the same Form D within in that state within 15 days of first sale, except in New York where you have to file it beforehand. Before you get any money. So that in a nutshell are some of the key requirements under Rule 506C. Let me know if you have any questions. You can always set up a call with me.